intelligent man, and his weapons are words, and he is very careful in the words he uses. And when he uses those words and says it's a legitimate state interest in prevention of fraud, he understands that these statutes that are now being challenged in the lower courts are based on, at least in the legislative history, based on the alleged prevention of fraud. And Justice Kagan even addresses this. She talks about, there's a lot of laws on these different areas that are now being enacted in the legislatures, and that's why we have a Section 2 to protect people. So he fully understands that he is giving that green light. Of course, he's not going to say he's not a legislator and he's not technically a politician, but he is clearly someone, I believe, with an agenda on voting rights, as is the whole Roberts Court, because let's look at the Roberts Court. They took away pre-clearance in 2013 in Shelby. They took away, for all intents and purposes, the intent test in Abbott versus Perez in 2018, where they said that the legislators have a high presumption of racial innocence and whether or not they intend something racially disparate. And now this test about effect from this case, I would say they are making the disparate impact results argument a very difficult one.
So do you think that Attorney General Merrick Garland, in his announcement just last week, that they were suing, the Department of Justice was suing the state of Georgia based on the new controversial and newly enacted Georgia laws, he focused and used the word purposeful and intentional as opposed to that resulted in. You have to wonder if something about the oral argument or something about their interpretation of how this court might rule was the reason he did not focus on the results aspect of it. You think that's the case?
Great point, Laura. I think Merrick Garland saw this coming, and he's a very smart and shrewd and highly intellectual and experienced judge. He saw it coming, and he said, look, I got to go the other way with this because I think they're coming at us on this Section 2. So we're going to go with the intent argument in the first instance. Yes, I think you're absolutely correct.
So where do we go from here in terms, and by we, I'm saying the people who are going to be fighting these cases involving Section 2 violations and the like. And, frankly, the two laws at issue in Arizona, I hate to call them small potatoes compared to, but they're not as egregious, of course, as other laws that have been attempted to be enacted or implemented already or trying to be in other states. I think it's 14 other states may have laws that, frankly, go even beyond the ideas of so-called ballot harvesting or throwing out ballots in the wrong precinct. Is this any indication at all of how the Supreme Court might, if those cases come before it, how the Supreme Court might rule on those other cases if they have this approach to these two areas? Is the fact that these are not as egregious to people as others signaling that maybe the Supreme Court is not as hostile as people think it is right now to voting rights?
Okay, so we have, I think right now we're up to maybe 17 states, 28 restrictive laws, something like that. It could be 13. Wow. It changes by the day, as you and I know. So what happened today is not the worst possible decision, okay? That's the good news. It did leave open challenges under Section 2 about disparate impact, but it certainly raised the standard high. It created this new, as Justice Kagan said, made-up factors that make it much more difficult. So I would say that based on the Roberts Court's decisions in 2013, 2018, and today, they are hostile to voting rights in general. I think it's fair to say. And number two, unfortunately, we have a Congress where obviously in choosing between democracy and the filibuster rule, right now we're at the filibuster rule. So I think that we're lawyers. So what do lawyers do? We always fight. So do we take a gut punch today to democracy, in my opinion? Very much so. And are we a little on the ropes? Sure. But that doesn't mean that the match is over. And obviously all these state laws are going to be challenged in court. They may one day reach the Supreme Court. Not overly optimistic. I mean, it'll have to be a terrifically tailored argument and a little bit more receptive court, and I don't know where that's going. So I think two things. Number one, as I mentioned, Congress, but we've got big problems. Number one to me right now, voter education. Because if we just get people out there and they just check their registers, they do all the things they need to do, and they're educated on it, that's how we can beat this without the politics.
Hey, there's in furtherance of education, there's a great book out. It's called Voting, the Ultimate Act of Resistance. It's written by you, Richard Bell, New York City voting and civil rights trial attorney. Again, it's called Voting, the Ultimate Act of Resistance. Thank you as always for your time. Look forward to talking to you again. Thank you.
Thanks again, Laura. Such an important issue. Thank you.